It's Monday night. Happy Memorial Day. We are hosting our Facebook Live on the Monday, and I have criminal defense attorney Sam Geller from the Geller Law Firm. As you all know, I'm Christina Malian. I practice in Glendale, California. My main practice is personal injury, and also part of my firm does estate planning. My office is located in downtown Glendale, and I've been doing this for nearly 9.5 years. I have decided to bring on different guests during our programs and during COVID in order to discuss topics that most of you have asked me about or that you may be curious. With tonight's guest, we are going to talk about some serious topics and some highlights of a lot of questions that people may have during a pullover when an officer pulled you over. So tonight's topic was going to cover domestic violence. We're going to get into some conversation about that and see what resources are available to our audiences. You can ask us questions throughout the program, and when we get to it, and if I can read off of it, I will ask our special guest to answer some questions. And further, as we continue our conversation, given the fact that it is Memorial Day, we will be discussing some do's and don'ts when a cop pulls you over. We'll get into the facts of what you should do, whether or not you should take the DUI test, if you're being arrested, if you're being detained, what your Miranda rights are, and the conversation could lead on to anywhere and everywhere, depending on what questions we get. With that said, I want to invite my guest, Sam Geller from Geller Law. He comes all the way from San Francisco to join us this evening, dedicating his time and his knowledge with you all. So, hi, Sam. Thank you so much for joining us.
Hey, how are you? Thanks for having me.
Thank you. Now, I know you've been practicing for about 7 years. Can you give me a background of yourself, like where you're from, in the sense of like what areas of practice do you do, and what does criminal law defense entail?
Okay. So I'm a Bay Area native. I grew up in San Francisco since moving here since I was about 7, 8 years old. I went to college. I went to law school in San Francisco. Afterwards, after completing the bar and passing the bar, I volunteered at the public defender's office in Marin County and SF County here. And then afterwards, I started my own practice, started telling people, this is what I do, and slowly grew my business. And, now I do criminal defense, which means that I represent people who are alleged to have committed a crime, whether that means it's a DUI case or a drug case, domestic violence, more serious cases, burglaries, thefts, whatever it may be. And I work in all the Bay Area counties around here.
Very nice. And I know with criminal law, there's also like white collar crime. Have you dealt with any of that? Do you do that in your practice?
I do that. I've done several white collar cases. And surprisingly, the white collar cases that I have done have been federal cases because they were, offenses of, major fraud allegations.
Okay, very nice. With that said, I want to get into our first topic. And I know it's a heavy topic to discuss. And for our viewers, if you know anybody suffering regarding domestic violence, we urge you to reach out to us and we will provide you with resources. And at the end of the segment, I will put up links of whatever we discuss. Now, Sam, domestic violence can be misconstrued. And I know it is very much on the rise because of COVID. People are in quarantine, people are at home, people were home, and people were, in a very tight situation and space. Typically, there's a myth that domestic violence is only between a girlfriend, a boyfriend, a husband, or a wife or spouses. But that's not necessarily true. So I want you to touch upon what domestic violence...
Christina, I'm sorry, I'm having a connection lag.
If anybody's tuning in on Facebook, we are having some internet difficulty, but I think Sam is back, yes?
I'm back, yeah.
Okay,
no
problem.
Back on right.
So just to repeat, I was saying, Sam, there's a myth that domestic violence only is between spouses or a girlfriend or boyfriend. But that's not necessarily true. I want you to touch upon it. And also, if you have any devices that you can turned down. I think it's bleeding into our feed. But go ahead and touch upon the domestic violence.
Okay. Let me know if it continues that way because I don't have any devices that are on.
Okay. It's okay. So talk about domestic violence.
A lot of people, oftentimes think about domestic violence, and when we talk about it amongst our friends or, we hear it on TV, it's always most often related to, boyfriend, girlfriend, girlfriend, boyfriend, 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 girlfriend, girlfriend. In the criminal context and in the civil context, if you're having an issue, with a father or a sibling or a cousin or a familial relationship that you have, it is also considered domestic violence. So to that extent, it doesn't have to be just, couples.
Okay. So it could also be, so a parent-child could be domestic violence as well, correct?
Correct. Yes, that would be considered a familial relationship. And then there are statutes within the penal code that say if one person is convicted of a crime that involves a familial status victim, then they have to comply with certain conditions if they're placed on probation, such as completing anger management classes or, domestic violence classes, parenting classes, whatever the applicable case may be.
Okay. With regards to domestic violence, the reverse is also true too. It could be child to parent as well.
Correct. Yes. Any sort of familial relationship.
Okay, and that's very sad because a lot of elderly parents can be taken advantage of it. Now, when we talk about domestic violence, we think about black and blue eyes, stabbing or whatnot. Obviously, besides the other types of crimes that may be involved with that, what forms of domestic violence or situations can lead to be considered domestic violence? The physical aspect and the verbal aspect.
Correct. So, there's obviously some things as verbal abuse, there's harassment, there's stalking, there is, threats that can be made. Those, from a criminal perspective, those things for a prosecutor are harder to prove. But when it comes to like experiencing or being a victim of domestic violence, all of these things count. This is a form of harassment. And it disrupts people's lives. It ruins relationships. It doesn't have to be, just physical violence all the time. It can very well be other forms of harassment.
Okay. And if they are getting, abused physically, most importantly, what can you urge or what can you tell the audience and our viewers eventually to do? Like, what should they do? Do they have an appropriate forum to go to? What should they expect?
So the easiest thing, obviously, if you're being abused physically, especially, or however you feel you want to define abuse, the easiest thing to do is always call your local police department, right? If the police department comes out, they come into your house, they separate the parties, they end the argument, and they determine who is the aggressor and who's the victim of the case. And then oftentimes they will arrest the aggressor, which means that the situation is being removed from your house for that time being. And then they also issue a restraining order that lasts for 7 days upon them leaving your house. So that means that the aggressor, now being the suspect, is not allowed to communicate with you until that restraining order is expired. And then what can happen if a case is actually filed, oftentimes the prosecution will ask for that restraining order to be extended further.
Okay. So with the one that's filed for 7 days, is that the EPO? Is it the emergency protective order?
Correct. That is the EPO.
Okay. What if the cop doesn't know who to believe, but believes that both of them could have been the aggressor? Is it possible, or have you seen situations where both parties get arrested?
It is possible, and I have seen it. It happens more often than people would think. But I don't want to say that from the perspective of, to discourage someone from seeking help because they're in the fear of also being arrested. If you're truly a victim of domestic violence, you need to seek help. That's the easiest way to do it. In the alternative, if you don't feel that, getting the police involved, getting the court system involved is an option for you, then you can always obtain a civil domestic violence restraining order. That takes a little bit of more effort on your part because you have to file the paperwork, submit the paperwork, have a hearing date, But if you file the paperwork, you hear back within 2 days whether they grant the restraining order for a temporary time. But that way you don't get the police involved. A lot of people don't want to have police involved in their family problems. They feel that maybe they can just fix it this way.
That's a good point. And, I do want to tell our audience the misconception that it's always a woman being beaten up or a child is not so true. There could be males that are also being abused physically, and also parents. So don't be afraid to call if you're one or the other, or any gender or any, class, because you have rights and you have to protect yourself. So you mentioned a good point. Now, when you get the cops involved, and let's say one or both parties are charged, it doesn't matter who's charged, but somebody's charged. Essentially charged, meaning they are arrested. Sam, I think I lost you. I don't know, your connection is coming in and out, but for those of you, until we get Sam back, we're talking about domestic violence and calling the cops, and once you're back, Sam. So when you get back, whenever you call the cops and you get arrested, what does that mean in normal situations, and what does it mean during COVID because of the fact of the court procedures and the lockdown?
So normally, if you are arrested for domestic violence, you're going to be taken to the police station where you'll be booked on the charges. Afterwards, depending on the severity, and most of the time, in some counties, you'll just be released because they don't consider you a public safety risk and they don't consider you a flight risk. Okay. And sometimes they'll set bail. That depends on your bail schedule, whether it'll be 10, 25, 50,000. You can contact the bail bondsman and, obviously bail yourself out. While you're in jail, however, if there is a restraining order, it's always important to remember not to contact the victim in your case. And then 2, not to discuss anything about your case on the phone calls that you make or people that you talk to in jail, because especially the cell phones in the jail calls in these situations they're recorded. So if you say something or you express something in your jail calls, that will then be used against you in your case.
There's no reasonable expectation of privacy in a jail.
No.
Okay. So the point and the message we want to communicate for tonight at this point is, when you call from the jail, first of all, be careful what you say. Keep it to the very minimum. And most importantly, don't start chatting up and making friends with, your neighbors and your jail cellmates. They are not your friends. And, I have a question. You remember from law school, like the jail plant, they'll plant like a spy or stuff. Is that still taking place?
Oh, absolutely. I mean, I have a hard time believing that it happens often on domestic violence cases. Uh-huh. But I mean, you just never know. That's why, I feel like if you're in jail, the only time you should be making a phone call is just to tell people just tell people that you're in jail, obviously.
Okay.
Get out of jail, or to call your lawyer.
Okay.
Even me as a lawyer, I don't talk to my clients about their case over the phone. Like, I've had plenty of times where, opposing counsel knew exactly what we're talking about, and I never said anything outside that phone call.
Oh, and that's because probably somebody's talking. So, question about domestic violence. When you say familiar relationship, does it mean you actually have to be living with that person, or could it be when couples or parents or whoever that relationship bond goes to do not live together, but the abuse is still taking place, even if it's once a week or once a month?
Correct. Yeah, there's no necessity for you to live together. I mean, there's oftentimes, a boyfriend and a girlfriend or a couple go to a bar, they get into a fight, they live in separate homes. That's still domestic violence. It doesn't require any sort of living in the same place.
Okay. Sorry, I am getting messages that they cannot hear me. My mic is on. Let me just reply to a comment. So yeah, we are taking messages live, and Sam, we do have a couple of questions. So before we continue, I want to ask you this question. If a party pleads no contest to a criminal DV charge, and the court therefore adjudicated them guilty, what ramifications or impact does the finding of guilt have in a subsequent civil or family law case? Does res judicata apply? And if you need more information, we can definitely let the audience know that you can address it in a little bit. But if it's something you can answer, let me know, and then we can, answer that question.
I think that in the most vague term, without knowing more information, that whatever happens during that, if you entered a no contest plea, the reason why you would enter a no contest plea is so that then in civil court, they can't use the resolution in your criminal court for finding of liability or guilt in a civil sense.
So
if
in
you plead,
civil matter, you have to do the prove up separate from what you pled in the criminal matter?
Because the burden of proof is different, right? It's beyond a reasonable doubt in criminal court. And then when you enter a plea of no contest, it will have an impact of a guilty plea for your criminal case.
Right.
But it cannot be used against you in your civil case.
We see that a lot, Sam, with traffic tickets. And I know you don't do traffic tickets part of your practice, but the judge reads you your options. You can do guilty, not guilty, or no contest. And then they explain further that no contest has no bearing. It should not have any bearing in the civil matter, but it's just within the proceeding. So very similar to that, right?
Right. Yeah. So it's like if you're involved in this, if you're speeding and you're involved in an accident and you're the liable party, you don't want to plead guilty to speeding, well, because then you just admitted liability for the opposing party in your PI case.
Oh, definitely. I would love them to do that, because then I could go off of it, and not that everything would come in, but to a certain extent it might. So, okay, I want to definitely get to some of the questions that had come in throughout our time. Now, we did talk about the police and the aggressor and being in jail, but I want you to touch upon what charges are they facing? Is it a misdemeanor? Is it a felony? And how does this affect one's reputation and criminal background? So can you please let us know about that?
Yeah. So depending on the severity of the abuse, so if there's like a broken hand or a bleeding eye, or something that there's blood, you'll most likely be charged with a felony. It obviously also depends on counties, because different counties treat things differently.
Okay.
And then if it's something below that, if there's no bruising, just like a red spot, most of the time, I think in most counties, you're going to be charged with a misdemeanor.
What are the charges being filed initially? Are there not or no charges being filed? How does it work? Do you get arrested and then you're behind bars and now you have all these charges pending, or does the DA decide? How does that work procedurally?
So when you're arrested, you can be arrested on one charge, right? Afterwards, a police report is generated by the police officer and forwarded to the DA's office. Maybe they need a further investigation, so they contact witnesses and things like that. Okay. And then it's the DA's job to determine what charges they're going to file. So, for example, if you're arrested for hitting your spouse,
okay, and
that's all you're arrested for, and then later they find out that you also broke their cell phone, so they couldn't call the police. The DA will add a charge for destroying a communication device that was meant to be used to call the cops.
Okay.
So just because you're arrested for one offense, you can be charged with less, or you can be charged with more or different offenses.
Okay. Now let's say you're charged, and actually whether you take a plea deal or I'm not sure how that works. I'm sure plea deals work in domestic violence cases and charges may or may not get dropped. But let's say you get convicted. Whatever the charge may be, and you're convicted, what should one know about a domestic violence charge and conviction on your record? What does that mean for a person in that situation?
I mean, for starters, it obviously ruins your record, right? And then if you have a conviction, you have to disclose it. There are companies, there are professions where you can never work in that profession because of a domestic violence charge. Secondly, you should know that in the event that you're involved in a similar incident in the future and police officers know that you have a prior criminal history of domestic violence, you're probably more likely to be seen as the aggressor because now you have a history.
So wait, when in the subsequent incident, police officer comes to your door, punches your name, a license plate, a license number, and knows that you actually have a charge pending?
Yeah, they can pull your record. They can check if you're on probation. They can check if if you have conditions that they can search you without any probable cause. They can pull all this information. Obviously, if they know if they know the information.
Right. Which they do. They ask you for your driver's license when they come. They want to make sure you're the person. They check your address. They do their, they have to do their due diligence to ensure their safety as well.
Right. Exactly.
Okay, so it lasts on your record. How long? And can you get it off your record if you have a DV conviction?
So it lasts on your record forever in California. There is what's known as an expungement, commonly referred to as expungement, and it doesn't. If you're successful and you ask for them to dismiss the case in interest of justice, it'll just show up on your record that you were convicted and your conviction was dismissed pursuant to the expungement statute.
Oh wow!
It'll always be there if you're convicted.
Always
Yeah.
there.
Unless, of course, it's like a unique situation, you withdraw your plea, you appeal it, and then you file for like to delete the record completely. But it's, that happens, don't get me wrong, but it's not the common thing.
So you mentioned a key word that I think most of us have heard, expungement. And, just in terms for this, does it mean that you just wipe it off your record and that's it? Like what effect does an expungement have on one's record?
So for purposes of employment, if you are successful in your petition for an expungement and you apply to a job and you're asked if you've ever been convicted, if you had a record expunged, if you had one conviction expunged, you don't have to disclose that conviction. You can comfortably say, no, you've never been convicted.
Okay.
It'll say that your case was dismissed.
Okay. But with regards to not only getting it expunged and getting it outside of your record, are there places where it will show up and they can hold it against you?
Of course, like law enforcement will always see it. Immigration courts will always see it. Anytime you travel, they'll see it. So like law enforcement always sees it.
Okay. Moving on to law enforcement and cops. I think we touched upon what we should or shouldn't do when somebody's in jail. What's the number one or two or three things, top 3 things you would recommend somebody to do, especially in COVID, with regards to being booked and arrested and behind bars?
That's a loaded question. One, it's by county. It's county by county. So like here in San Francisco, all over California, we have this concept of, $0 bail. So most people are just getting released. If you're not getting released and you are a person who is an at-risk individual, then if you can't afford bail, you should bail yourself out just so you can get out and go back home.
So
right? Because
would you say number 1, call an attorney, number 2, call a bail bond? Like what order would you?
So if you can reach an attorney, like if you're arrested in LA County and you can reach an attorney in LA County that there's a good likelihood that attorney would know what is the current conditions of how people are being released, right? Okay. And then an attorney can always connect you to a bail agent that they work with who'll take care of you.
Okay. Now, I know it's COVID time, and whether or not things are opening up or not, what is the fear about getting arrested and behind bars? Like, how soon are you being in front of a judge to get all of this handled? And are there delays because of the virus?
So in California, they said that, so normally if you're arrested for a misdemeanor, you have to be, if you're in custody, you got to be before a judge within 48 hours.
Okay.
If you're arrested for a felony, you have to be in front of a judge in 72 hours.
Okay.
Now with COVID, it's actually 7 days.
Wait a minute. So somebody could be behind bars for 7 days?
Correct. Before they see a judge. And that's a very long time. Like that's time that you can't see your family. That's time where you can't go to work, take care of errands, potentially miss important, whatever it may be. 7 days is a lot of time.
That's insanely a lot of time. And I mean, not to get into constitutionality, but I mean, this is what it is, right? And where we have to deal with it, and the attorneys are dealing with it. Are things changing up in court? Are things changing in the San Francisco area regarding court opening and closing?
Yeah, so I think it's by county. Like one of our counties is opening up tomorrow. One other county is opening up in a couple of days. So different counties are determining, what is their best way to open up. I mean, this was very difficult for the courts, right? There's a lot of people who are facing charges, who have rights that are guaranteed by the Constitution. All of this got basically postponed, everything. And the courts were closed, handling just serious cases for the most part. But now things are starting to open up again. And, we're being told, in some cases you can show up by video conference. In some cases you have to show up in person, whatever it may be.
Very good. And that's good news. And we're moving forward. I want to get to like a little bit more lighter topics. I hope we covered enough. Oh, one more thing. Is there a victims protection program or resources where people can reach out to if they do not want to go through the cop or the law enforcement route to get help?
I didn't hear the beginning, but I think you said, are there resources that people can reach out to if they don't want to reach out to law enforcement?
Yes, for domestic violence.
I think it really just depends on the county. Like here in SF County, we have a lot of resources people can reach out to. I think that the best thing to do, if you're looking for resources or you think you need to be looking for resources because things are getting tough at home, maybe just Google a couple of resources and have that information ready so that in case you need it, you can use it.
Okay.
You want to be proactive because a lot of us, live in and have relationships where things get heated. One of us leaves the house, and you can't do that anymore, right? So people are having a hard time battling. And then if you feel like you're going to be abused or you already have been and you're just waiting for the next time, have your information ready.
Look, to our audience and to whoever sees this message, domestic violence is a serious issue. It's not just a one-time thing. If you feel like you're a victim or you are being abused, we urge you to reach out to us. You could even reach out to us privately by messaging us on Facebook or contacting our law offices, and we will put you in touch with the right people. But, we urge you to take the stance and not to allow the abuse to continue, especially if it's repeated. Even if it's a one-time offense, one time could lead to multiple times. So I know it's a very heavy topic. I know it's taboo, and we all want to get, we all think it will get better, but unfortunately, before it's too late and before somebody not only ends up behind bars but ends up 6 feet under, unfortunately, that's where it heads to, and we've seen it in our practices a lot. We urge you to reach out to us, and we can get you the right help, and we will keep it anonymous, and we will keep it with the attorney-client privilege, so we do not have the right to disclose it to anybody. So Sam is always available as a criminal defense attorney. My office is always available to put you in touch with criminal defense attorneys or the right workers to help you. I want to get on to lighter topic, even though it might not be too light. It's Memorial Day. If it was better times, pre-COVID, BC, we would have been out drinking, partying, driving, hopefully not drinking and driving, but we get pulled over. There's things that we know what to do when a cop pulls us over, when the sirens go on, or when they're, speaking through the speakers. I want to know more, and I want to help this conversation be facilitated to our audience to know what to do. And not that we're going to provide you with an exhaustive list, because we can't ascertain all circumstances, but we can give you some guidance. So Sam, let's start with, before we get into drinking and driving and DUIs, if you see the sirens on and the cop, it looks like you're being pulled over, the first thing we've been taught is make sure that you're exiting or pulling over to a safe zone where you can park your car. What is the very first thing you should do? Should you leave your engine on? Should you turn off your engine? Can you guide us through some, practical things?
Yeah. I mean, so just from experience, and I've been pulled over several times in my life, I think that what I've always tried to do was that I pull over as quickly as possible, and I try to pull over in a place where it's safe for myself and it's also safe for the officer, right? At the end of the day, they're doing their job, whatever it is that, that may be. What I personally do is I immediately open my windows because I want them to feel safe. I don't want to have any trouble.
All 4 windows?
I personally do.
Okay, if you have 4 windows, 4 windows, 2 windows, 2 windows, okay.
Correct. I can understand why certain people won't, obviously, because of the field that I work in. But me personally, I got nothing to hide in my car. I open my windows. I turn off my car. I put my keys on my dash, and I put my hands on my wheel.
10
right? 10 and 2, exactly. And if I can, because I usually keep my wallet next to my cup holder, I just put my wallet up there too, so that when the police...
your wallet's like behind your pocket and you're scrambling to pick up it, and the cop might think that it's something else. How do you...
I hate to say it, but I think, like me personally, if I'm in a place and I feel like I can just take it out and just put it there, I personally do. With everything that I see on TV, you know, if you're like a person of color, you know, you're Black, Hispanic, depending on where you are, I'm not in a position to discuss that. But me personally, I would never be reaching in any of my pockets, any in my doors, because it's
They're
just the
gonna
world that we
suspect
live in.
something. Yeah.
It's just the world that we live in. I would just wait, and if I'm asked, I would then tell the police officer, you know, officer, my wallet is in my right pocket. I'm gonna go ahead and reach for it. You know, try to make sure he can see. Go slow. You know, you want to make everybody safe. Me personally,
Do you unbelt your seatbelt, or do you keep your seatbelt on?
I keep my seatbelt on because there's no reason for me to unbuckle it.
Okay, you don't unbuckle. So first things first, what Sam does, that is not suggesting for everybody, you know, depending on your situation, roll down your windows, turn off your engine, put your keys and your wallet, if safe and possible, on top of your dashboard. Keep your hands on 10 and 2. Great. What's the next thing you would do? The officer comes up and says, you obviously knew why I was pulling you over. And you say, yeah, I do, because I was speeding.
Yeah, so oftentimes I feel like it's a trick that they use to say, excuse me, sir, do you know why I pulled you over? And by you saying, yes, officer, because I was going 87, you're essentially admitting it.
And they're writing that down behind the ticket.
And
so
now
they're not, they are.
Now it's on their body cams, or it's being recorded on their microphones, right? So there you are, admitting to guilt. So you say, or you don't say anything, or you say, I don't know, and you just don't say anything. I mean, to that question, right? If you already know because you're going 100 miles an hour, I would still not answer because you're getting a ticket anyways.
Yeah.
Like, you know damn well you're going 100 miles an hour.
So what do you say? Like, you don't want to be rude. You don't want to be like spaced out, right? You want to be like, no, officer, you know, why did you pull me over?
I flat out say, I have no idea.
Okay, I have no idea. Great tip. Then what happens? He does what? The officer does what? Or he or she?
They tell me I'm pulling you over for this and this, whatever it may be. And if I can have your license and registration and insurance, my wallet's already on my dashboard. Obviously, I hand it over. I take out my ID. My insurance card's in my wallet too, so that's easy. And then my registration is just above in my visor. Okay. So I just hand that over and I wait.
What if your registration's in the glove compartment on the passenger side seat? Do you inform the officer that the registration is there and that you're reaching out, or do you just go for it?
You inform the officer, right? I feel like if you're respectful and it's just one of those, I mean, there are exceptions, don't get me wrong. But if it's just a routine traffic stop and you're respectful, what's going to happen is that officer is not going to give you any trouble. There is a chance that you get out with a warning, right? And if you then fight that case in court and you challenge it, that officer might be like, you know what, screw this. That person was super respectful. I get it. They probably learned their lesson because they were terrified anyways. And they don't even show up to your trial. So you win anyways.
Oh, very nice. Good tip. So be respectful. They're doing their job. They're here to protect us, even though some may, you know, cross the line, and we won't get into those, but they're just doing their job as we are doing ours. So the whole point of informing the officer is not because it's an inferior or superior thing, it's because they're looking out for your safety, their safety. And if they feel safe and they don't feel threatened, you can actually go a long way with kindness. But if they feel threatened, if you're going to reach for an object or a weapon, then they're going to take precaution. Now, great information regarding the traffic routine stop. But now the cop is looking because you've rolled down your windows and you forgot that there may or may not have been things that he should see. And in plain sight, he sees something that raises suspicion. And for lack of better terms, and people may have heard the terms probable cause, without getting into the legality of it, at what point can the officer say, please step out of your car, or does he say, please step out of your car, I'm going to search your car? How does that transaction take place?
I mean, if you open up your back window and you have a pound of weed with scales and baggies, and the cop sees that on your back seats, the cop now can search the rest of your car for weed, right? Generally speaking, if that's not the case, an officer needs something in order to search your car. He needs some
Sorry, can you repeat that again? If he sees weed in the backseat of your car with scales, he can search your car?
Absolutely, because obviously
it's legal in California. How can he search your car?
If you see a bag of weed, so you can have 28.5 ounces of weed for personal use.
Okay.
Right. If you see like a pound of weed in the backseat of a car with scales, with baggies, for example, to like separate the weed, any reasonable person would think that the person who's driving this car or someone in the car is selling weed.
Is
right?
selling weed still illegal in California?
Absolutely, yeah.
Okay. So we'll get into the weed conversation.
Yeah,
But okay. So, all right. So in plain sight, he sees something that is illegal. He has a right to search your entire car, right?
Correct.
Even your trunk?
Even your trunk. If he feels that he can find weed in your trunk, he can search your trunk.
Is there a situation where he cannot search your trunk?
There are, like, if what they're looking for cannot be in a trunk or a glove compartment, then they shouldn't be able to open it, right?
Oh, so glove compartments are protected as well.
To a degree, yeah.
Okay.
Yeah, if the glove compartment, like there was that Jay-Z song, right? 99 Problems that was written back in the day. I think that for the most part, it gets it half right. But there are definitely situations when your whole car is searched.
Okay, and that applies to cars that have a separate trunk and a separate hood to it, and it also applies to cars where, let's say, a Scion XB, where the trunk is connected and is part of the car, correct?
Yeah, I would say so, yeah. I think that obviously, depending on the circumstances, there could be an argument to be raised here and there. But I think just like, as thinking about it now, it can be searched.
Okay, does the cop ask you to step out of the car before they search the car? Typically.
Yeah. Normally, they should ask you to step out of the car, and then they'll probably pat you down for weapons.
Okay.
And then they ask you to take a seat, and then they search your car.
Okay. At that point, are cops supposed to read you your Miranda rights when they're searching your car?
No. So there's a major misunderstanding, I feel, in the world about Miranda rights. So just because a police officer is talking to you, or just because you're detained or you're sitting on the curb, the law now says that, or always has said that, you don't have to have your Miranda rights read. Like if I arrest you and then I ask you, hey, where were you born? And it's in no way incriminating, then that's not a violation of Miranda, right? Miranda has to be read to you after you've been arrested. There are arguments that we as defense attorneys make that someone should have been considered arrested at that point, like de facto arrest. But if you have been arrested and you are going to have a custodial interrogation, meaning that you're going to be in a confines where you can't leave and be asked interrogatory questions, and your Miranda rights were not read to you, then they're in violation of your Miranda rights.
Okay, so we're going to get into Miranda rights because I think I want people to know. And when we launch this on YouTube or any other platform, I will put it in segmented format because I want people to know their Miranda rights and to know the do's and don'ts. But a general statement, not to say it's applicable across the board, is that they do not have to read you your Miranda rights when you step out of the car and when they search your car. But the minute they find something to arrest you and they're going to handcuff you is the triggering point whether or not the Miranda rights should be read.
So the Miranda rights have to be read once you're under arrest.
And they have to tell you you are under arrest, or can they just handcuff you and you don't even know if you're under arrest?
I mean, that's kind of where the legal battles happen, right?
Okay.
Our argument is that the person's under arrest, and then there's case law that says, no, they're not. So it's very situational and subjective, but if your handcuffs are on and you're in the backseat of a car, you're under arrest, right? Yeah. And if you're asking you questions like, hey, whose weed is that? And you answer and they didn't read your Miranda rights, then that's in violation.
That's a
violation. They have to read you your Miranda rights.
Okay.
After you've been arrested to continue talking to you. If they have no intention of speaking with you whatsoever, they don't even have to read it. There's no violation.
So as a practitioner, would you recommend a person in that situation tell the cop or ask the cop, am I under arrest? Read me my rights. Or do you recommend that person to say, I want to speak to an attorney because I know that triggers a condition? Right. Or do you recommend them to talk as much and go off babbling because they know their defense attorney, Sam Geller, is going to get them off the hook because they didn't read my Miranda rights? Like, what do you say, what, as a prudent person who suspects that they're under arrest but doesn't know, what should they do?
I think that the best thing to do is to ask the officer if you're under arrest.
Okay.
And if you're not under arrest, then you should ask if you're free to leave. If you are under arrest, you should ask what you're under arrest for.
Okay.
And then you can say, I don't want to make a statement and I want to speak to a lawyer.
Okay. And at that point, they should, they don't, they should stop talking. And when they if they stop talking, that's great, but they're not. They're going to trigger you. They're going to talk. And we don't know, but you and I know that they start chatting it up between the buddies. They make conversation. They become friendly with you. They want to know you better. They all of a sudden say, listen, we can get this deal. We could do this. We could do that. Is that all true? Can they really do that?
Yeah, I mean, they really can. I mean, I've had situations where somebody was, arrested for having cocaine, and then they were asked to be a part of their, investigation and be undercover for them, right?
But could the cop have the authority to make those calls, or does the judge have to make that call?
Cops do that.
Okay.
Yeah.
Okay. So this isn't Money Heist. This isn't where.
Yeah. No. Yeah, for sure.
Where like one federal party's working for the other. Okay, got it.
Exactly.
So I know you brought up weed, and I think it's a good topic to talk about because we know that weed is legal statewide in California. And everybody, we're just talking about California. We're not going we know that weed is illegal in federal law. So a cop pulls you over and notices or smells, weed. Initially, just the fact that you've smoked weed or had the influence of weed, that is that in itself is not illegal, correct? Let's say you're a passenger. I won't get to the driver. Let's say you're a passenger that smells weed.
If you're a passenger and you smoke weed, that is not illegal. Obviously, there's age restrictions, right? But that is not illegal.
What is the age restriction for California?
I believe it's 18.
Is it 18 or 21? I'm not sure.
I'm not sure because I just don't pay attention to.
Our viewers know what the legal age for smoking weed is, 18 or 21. So I'm curious to know that. Whatever it is, your legal age, that's not grounds for arrest or being detained or any of that. Okay. What if you are the driver and you get pulled over for a routine traffic stop because you blew a stop sign or you were speeding, whatever it was, and the cop notices or smells weed off of you? Is that grounds for arrest? Not arrest. Is that grounds for further charges to be filed besides, a speeding ticket?
I mean, if they find a way to investigate, to search your car or investigate you for driving while under the influence of marijuana, then yes. But a couple years ago, under Prop 64, marijuana was legalized in California. It wasn't decriminalized; it was actually legalized, right? So now the smell of,
right?
I'm sorry?
There's a difference between legalization
and
I
mean, it's correct. It's just like cigarettes, or it's just like being able to breathe air. It's legal.
Okay, by the way, 21 is the age. Yay!
Okay.
Yes, somebody said 21. I don't know if that's true or not, but thanks, Steve, for chiming in. Okay, 21. So it's legalized, and then?
Since it got legalized, now there's been cases that have come down from the California Supreme Court, the Supreme Court that say, so at first it was the smell of unburnt marijuana alone is not sufficient for there to be a search of your car. There has to be something more, right? What that something more is, it depends on the case, right? But if they see the fact that, there's a lighter or there's a tray or something like that, right? They can consider that's more. Now, as of recently,
and driving at the same time, or is that equivalent to drinking and driving?
That is equivalent to drinking while driving. While driving,
okay.
Yeah, right. Because basically, when you smoke weed, you're usually your highest between the 7th and the 28th minute, right? Okay. So if you're smoking weed and you're getting high and you get pulled over, proving weed DUIs is very difficult right now, but it's being worked on because it's becoming a major issue. But you shouldn't be smoking and driving. That is illegal.
Okay, so is it difficult to prove because of the tests and how they test? What's current?
Yeah, like with DUI laws, we have a per se law. If you're 0.08 or higher, you're driving under the influence. We don't have that with marijuana because, like, if you've been smoking for the past 20 years and I smoke once every 2 years, your tolerance to marijuana is significantly greater than mine. So for me and you to smoke the same, like, weed, like a joint, and to take like 2 hits each, it would have a different impact on you versus me and the next guy. That's why proving the impairment is is almost impossible to a degree. So they're trying to determine whether or not we should have a per se rule. Like if you have 5 nanograms of active THC in your system, you're considered under the influence no matter who you are, right?
How are you testing the THC? What kind of a test?
Now it's blood.
Blood?
Now it's blood.
Okay.
Yeah.
So, but is it done like when you get pulled over, or is it going to be done in a facility where it's like an hour later?
Yeah, so they got to do an investigation. Then they got to take it to a place. Then they got to call a phlebotomist. Then they got to take the blood. By the time that happens, you could have been high as a kite when you got pulled over, and you are just like normal in an hour later.
Okay, I just want to say to our viewers, we're not suggesting you guys get high and drive and get high while driving, but we're saying that they're going to start cracking down on it. They're very good at it, especially because it became legal, and to watch out. So definitely driving behind the wheel or being behind the wheel is not, it's illegal. Don't do that. But I have a question, because with regards to people being drunk behind the wheel while their engine is off, we'll get into that. Is it the same if you're high behind the wheel? People are parked smoking out in their car, and is that the same as being drunk with your engine off? And can that be also considered driving under the influence?
Yeah, I mean, you can definitely be arrested if your engine is off and you're drunk or you're high, because what they'll try to do is they'll try to say that, well, you were still drunk or you were still high when you stopped driving. Like if you're parked outside your house and it's 2 a.m. and they come there and you say, oh, I've been sitting here since it was 9 o'clock, and they like touch the hood of your car and it's warm, that's how they determine like it hasn't been 6 hours, because your car probably would have been cold by now, right?
Right.
Maybe you can win the case, don't get me wrong, but you don't want to be arrested, period. Like you'd rather just avoid that.
Okay.
So don't drink in your car if you don't have to, right? And don't smoke in your car if you don't have to, and if you think you're going to get stopped.
Okay. Now, going into the whole drinking aspect, and I don't know if I lost you on connection, but I think we're back. Okay. So on the drinking aspect, DUIs, and I think most commonly known DUIs are drinking and driving, or drinking under the influence, or driving under the influence. I know that bleeds into the weed aspect or any substance abuse. It's not just weed. You could be on cocaine, you can be on ecstasy, whatever. You cannot be in an impaired state of mind and be behind the wheel. Driving under the influence with relation to drinking. You mentioned that the BAC level has to be 0.08.
Correct.
And BAC is blood alcohol content.
Correct.
Okay. I want our viewers to know, when you get pulled over and you are suspected of a DUI, are you required, and is it mandatory, to take the field sobriety test upon being pulled over and asked to take that test?
So when an officer suspects you of a DUI, he then does an investigation to achieve the probable cause that he needs to arrest you.
Wait a minute. So are you suggesting that the DUI test is done after arrest or before arrest?
No, the DUI is done. So if you're pulled over and they say, hey, Christina, please step out of the car.
Okay.
At that point, their DUI investigation, the questions: have you been drinking? How much you drank? When? And the test: stand on one leg, walk a straight line, follow my finger. All those things are done by the So all those things are done in order to the cop to find probable cause to be able to arrest for a DUI, right?
Okay.
So those field sobriety tests are considered just that, field sobriety tests, and you do not have to do them. They are completely voluntary. And oftentimes, most of the time, they'll have a little handheld device called a preliminary alcohol screening test. That is also considered a field sobriety test.
What is that? What is that?
It's a little device that you blow into, and it tells the officers what your alcohol level is, but it's a preliminary test.
Okay, so for those who are joining us, who are just joining us in, because I saw a lot more people just added to our Facebook Live, thank you so much for taking your Monday night and joining us. We are talking about DUIs, what you can or cannot do, and we're actually talking about what's mandatory or voluntary. So going back into that, Sam, you're saying basically you do not have to blow into that device in order to, it's not mandatory. You can actually refuse. What would you say? Would you say I refuse I blow into this device?
So there's two devices, right? One of them you can refuse. The device that's a small handheld device, known as a preliminary alcohol screening device.
Okay.
You can refuse. You can just tell them, I refuse. It doesn't matter how you say it. You just make the understanding that if you refuse. Another thing is, you shouldn't lie. Like if they ask you, have you been drinking? And you just say, I choose not to answer that question, right? If they ask you, have you been drinking? And you say, yeah, I had a beer, but your alcohol level is 0.35 because you had like a bottle of vodka, you can be charged with lying to the cops, right? So you just don't answer the questions. So
you don't have to tell them whether you drank or not. You just say, I refuse to answer that question.
Correct. You don't have to answer. You have the right to remain silent before or after arrest.
Okay. And then you refuse to that little device. What test, if any, do you have to do at the moment you're pulled over?
So at the moment you're pulled over, you're not required to do any tests.
Okay.
If you refuse everything and they decide to arrest you,
okay,
they should then tell you that you have an implied consent to submit to a breath or blood test, but you can refuse. What they have to tell you is that if you refuse that test, your license will be suspended for a whole year with any exception. If it's a first offense, longer if it's a second or third or fourth.
So wait a minute. That kind of puts you in a really tough position, because here you are saying, I'm not going to answer your questions. I'm not blowing into this little device, and I'm not doing your sobriety test on like walking, talking, quacking like a duck. Yeah. But then the minute you are arrested, they ask you the same questions again.
They don't ask you the same questions again. They just ask you if you then want to submit to a chemical test. It's usually a big machine at back of the station or a blood draw that they determine what your alcohol level was.
And if you refuse that and are found
lose your license.
Intoxicated, or at that moment you lose your license?
You lose your license 30 days after your arrest if you refuse.
But if you're not intoxicated, you cannot lose your license, right? There's an argument.
If you refuse, then
okay.
you can still lose your license. Because that's just based on the refuse.
That is, I did not know that.
And then,
yeah.
And then if you refuse, they can also get a warrant and get it forcefully.
Okay, so best practice is refuse the voluntary submissions prior, but the minute they take you back to the station for blood draw or the other test, you should actually go through it.
Yeah, absolutely. Because if you don't want to lose your license, like for example, if you drive your kids to school or you drive for work, you getting a DUI, if it's not going to make you lose your job, you just have to find a way to deal with it for a month, right? Depending on which option you choose of how long you want to do a suspension. Otherwise, you lose it for an entire year, no exceptions. Well, that's the incentive, right?
That. And I don't think I didn't know that. I mean, I know some things, and law school doesn't teach you the repercussions of being.
Most people don't know this. Most people don't know this, right?
Okay,
so the best practice is you refuse the stuff that's voluntary. And if you're not going to remember this live video, if you get pulled over for a DUI, you just ask, is it voluntary? And they tell you yes. Then you say, okay, if it's voluntary, then I refuse. And then
is it better to do the one, is it better to blow in a machine or give blood? Because I've heard that, calibrations and all that technicality. What would you say?
This is how I would answer that. If you had like 1 or 2 drinks, or maybe 3 drinks, and you like finished off your beer and took off and got pulled over, I would submit to those tests.
You would?
Because that would show me that I have a rising alcohol level.
Which is what you want to argue.
Meaning that, hey, officer, when you actually pulled me over, I wasn't above 0.08, right? Okay. If I'm loaded and I had like 15 beers, I'm probably just refusing any field sobriety test, and I'm choosing a blood test because my blood will go down by the time I get my blood test.
We're buying time. We're essentially just buying time at that point.
There's situations where you're just buying time. I mean, there's no way to really know this, because you have to like really think about everything as this is progressing. Okay. So it's just something. Hopefully, I never get pulled over for a DUI because it ruins your life. But it's something that I would try to attempt to do at least.
So when you get pulled over for a DUI, and let's say you do actually get charged with it, what happens? Do you still tend to lose your license, then cannot drive for a year? Like, what are the repercussions of, first of all, let's not talk about the attorney's fees, how expensive it is to fight off that offense and how traumatizing it is. Moving on from the financial aspect, your life, what does life look like for your first offense of a DUI? And then I want to get into a second offense. So what is life?
If you're convicted, then you would need to complete a 3-month DUI course. You would need to pay fines and fees of about $2,000. Your license would be suspended for a period of 6 months, but you have ways to get it back either immediately or after 30 days.
Okay.
And then if you're a professional, for example, if you're an attorney, you're a nurse, you're a doctor, psychologist, any other profession that requires some sort of licensing,
yes,
you can potentially face, being suspended from your profession. You can be, suspended, you can be removed depending on how many DUIs you have. But like if you're a nurse, you essentially have to do so many things right away in order to make the nursing board believe that this was a one-time thing, because they're going to see it as, hey, what if this person has a drinking problem? And
or what if they come to work drunk and they're operating or attending a patient? Yeah, I mean,
exactly.
The consequences are multifaceted, at least to say. So professionals, be careful. Anybody, be careful. You're putting your life at risk. Let's not even talk about, and I know you do some PI too, let's not even talk about the fact that you could get into a car accident and the ramifications of being behind the wheel drunk and injuring is actually a felony, correct?
Absolutely. I mean, listen, DUIs are, nobody, promotes them in any way. They're terrible. They kill people. They don't kill you, they'll kill somebody else. You shouldn't do it. Right?
So at what point is it when, I've heard our questions have come up is that they have to attach that device to your steering wheel to unlock it every time you drive a car?
So that's one of the options, right? If you have been convicted and you have a license suspension, you can get your license back. And that is one of the requirements, that you have to have this device. I have some clients who have this device and they say, hey, Sam, this thing said I was drunk while I'm driving. So then the car stopped in the middle of the freeway and then I have to get it towed. So it's insane what's going on, but these things happen.
So that brings me to a good point. You mentioned towed. Your car gets actually impounded when they arrest you for DUI, correct?
There is authority for them to do that. Sometimes if they're nice, or if your car is parked in a nice spot, they'll leave it, save you a couple $100 and getting your car back.
And then look what you're dealing with. Your arrest, you're going to the station, your car is off the road, you have to contact an attorney, then you're probably contacting a bail bond company to get out. Like, you're just adding layers of stress and problems that you don't need. Don't get me wrong. Attorneys like Sam need you and want you, and you should call them. But this is what you're looking. You're looking at financial, emotional, mental consequences, and you should know that. Second DUI offense.
So like I just tell my clients that no matter how much your Uber costs, it is way cheaper than a DUI. Like
Thousands,
right? Thousands, literally thousands.
Like 100 times cheaper.
On second offense DUIs, you're now facing an 18-month DUI course, so a year and a half. You're facing a longer suspension. Again, your suspension depends on how you choose to get your license back, whether you want to do like a restricted license to and from work, or you want to get a license with the device that's in your car. But you're facing higher fines. Some places you're facing probation, and some places you're facing formal probation. Not really around here in the Bay Area, but like everything is just exponential, and you face up to a year in jail.
Whoa. Okay. We'll get to the jail part. But when you say you're doing 18-month courses, what are these courses? Are these Zoom courses that, we could log on, go to bed and sleep? Like what are these courses entailing?
It's funny you ask, because California is the only state in the country that does not allow online courses.
Good.
They do probably now because people have, deadlines to meet with court. But for the most part, you're not doing your course online. It's not like traffic school.
Once a week? Is it once a day? Is it once a month? What does it entail?
It's once a week. You can find different schools. There's different locations that work with your schedule. But 18 months is 18 months.
18 months is a long time. It's
Yeah.
yeah, it's a year and a half. Like, it's not a joke. You can have a kid and get pregnant at the same time. So it's a lifetime if you look at it.
Yeah.
So, okay. All right. And then the jails. And obviously we are over, if not beyond capacity, right? In the jail system and the prisons and whatnot. So the last thing you want to do is be in jail for however long your sentence is. Do you think it's the same type of courses for weed and being convicted under the influence for weed as it is for driving? And is the jail time the same?
Well, the jail time obviously depends on the case, right? The conviction and the exposure is the same. The school's the same. The fine's the same.
Okay.
Currently, the DMV doesn't concern themselves too much with the jail time, so the DMV won't suspend your license, but the court still will if you're convicted.
Okay, so either way, if it's suspended, it's suspended. You can't.
It's suspended, yeah.
So, what can people do or citizens do with regards to knowing their different rights when they're arrested? What should they know?
If you're arrested, you should know that you have the right to remain silent. You have the right to have an attorney present during any interrogation. I guess those are your rights when you're arrested, right? And then you have the right to be seen by a judge within currently 7 days, but usually 48 or 72 hours.
Mm-hmm.
You have the right to a bail hearing to see if you can be released. You can post bail. It's just things like this. You know, I always just tell people, like, if you think that you're prone to ever be arrested, then you should just have some information in your phone, you know, that a person you can reach out to.
And I know we talked about, and two more questions before we call it a night for the program. And I know it's Memorial Day, we couldn't get back to some relaxation, but two things. The weed issue, I know that statewide it's legal and federally it's still not illegal. So if a cop pulls you over, it's one thing, but if you're crossing the border where the feds are involved, it's a completely different ballpark, correct?
Yeah, if you're like crossing the border or you're in a national park, Joshua Tree you guys have over there.
Yeah.
If you're pulled over and they somehow suspect that you have weed or they smell it, that's fair game. Like, they can search you.
If you're in a national park, which is owned by the federal government, and you get arrested because they smell weed off of you, or you're intoxicated with the substance abuse, you can get arrested and you're in federal prison at that point. Like, state doesn't get involved.
Correct. You would be facing federal cases. So you'd be going to the federal courthouse.
Is that any different
there, which is a lot more. The penalties are much more severe, for one.
Oh, they are?
Yeah, it's like a whole different process.
Why? I mean, if you know, like, is it a policy thing? What is it? Or is it the fact that they haven't legalized?
No, it's a whole different process for all cases, not just marijuana cases. Like, federal practice and state practice are very just different animals. But anything in federal court, any penalty, anything like that is always much more severe.
Okay.
Which is why it's always terrible to face a criminal case. But having weed in your car, depending on the amount, is not going to be the crime of the year by any means. But again, you would be facing federal charges.
Got it. And final question with regards to DUIs, whether it's under the influence of any substance. Scooters are hot and they are commonly used, especially in beach cities. And I know that there's different types of scooters. One have motors, one don't. One's electric bikes versus non-electric bikes, bicycle. General concept or general advice to our viewers with regards to motored scooters and non-motored scooters. Can a cop arrest you if you are having a couple of drinks at a beach bar and then you get on a motor scooter?
Yes. So there are actually definitions of scooters and mopeds in the vehicle code. And if you're on a moped, which is a device that can be propelled by a motor engine, and it can reach certain levels of speed, then it's considered enough of a vehicle for a DUI. If you're like on a step scooter, I don't think that that's a DUI, but it is an infraction, right? So if you're on a scooter or on a scooter that you sit on, I have a case here now where somebody was arrested for it, and we're arguing in court that it was a scooter versus a moped, right? Because if it's a scooter, it's considered an infraction. If it's a moped, it's considered a misdemeanor.
Because
So
moped
it is
has the motor aspect of it, right? It's operation.
correct.
Okay.
Correct, exactly. So, but the bottom line is that most people, this is an up and coming topic. I assure you that, most officers aren't fully aware of the differences because all these things kind of look the same at the end of the day, and
Right.
they don't know what's under the hood. You're going to get arrested, and then you'll face charges, whether it's misdemeanors or infractions. It's a hot thing. It's coming up. It's definitely being prosecuted.
It's just a headache to deal with. So just walk on foot, and listen, you can still get arrested if you're walking on foot and being a disturbance to public.
Correct.
So
Correct.
well,
Basically, stay home.
yeah, just to stay home, especially with the lockdown. Final question before I let you go, Sam, is can I still get arrested for being drunk behind a wheel, even if my car is turned off and my keys are in my pocket?
Can you be arrested? Yes. It's subjective, right? Can you be convicted? You can be convicted. It's a harder thing for the prosecution to prove. It's an easier case for the defense to win.
Okay.
But it's going to have to be shown that you were in that car for a long time.
Okay. And like you said, the hood, the cops know what they're doing. Any final thoughts or, suggestions to anybody watching this at whatever time they get to watch it?
The only thing that I would just summarize is that me personally, I've been getting a lot of phone calls about domestic violence. And, while I do represent people who are accused of it, that's my job, and no way do I condone it. So if you are a victim, or if you've been a victim or anything, reach out to your resources. Don't be alone in this. There's people that will help you. So don't be fearful that it's going to get worse. It's a common fear amongst victims, but if you're a victim, you got to do something to protect yourself. So
And
I think now especially
letting us know that, absolutely. And I thank you for your time. And I think I want to end with, I think we've all heard this: shut up and lawyer up. Especially when it comes to criminal law, DUIs, being pulled over. I mean, traffic tickets, can go a little bit, but you could still be charged for like a handicap plaque violation and stolen property, driving under the influence. There's many facets. The minute you're charged with a misdemeanor, and you'll know on your ticket, first of all, you'll be read your rights as well. Just give us a call. If the very least, it's a free consultation to a certain extent, and then at least you'll know, and you'll know your rights, and you'll know. But the number one thing, or the worst thing you can do, I think you mentioned this, Sam, is like, if you think paying for a good lawyer is expensive, try paying for a bad one. And doing damage control is 10 times more expensive, and it puts us in a harder position that when we want to just do good for our clients. So
Absolutely.
With that said, thank you, everybody, for tuning in. My next guest, I'm going to feed off of doing these Facebook Lives and move on to YouTube Live on Malian Law. And Sam actually has a YouTube channel to Sam Geller, and I'll put all this information as well in our link. But tune into Malian Law. We're going to bring other attorneys, and my next attorney for next week is going to be a landlord-tenant attorney. I think there's rising questions as to what landlords are allowed to do. Can they evict? Can they raise rent? Can they get rid of the lease? What tenants' rights are to do? And because everybody's home, nuisance is a huge problem, and they're making noise and they're bothering people. So a lot of tenants want to know their rights. So that's my next guest for Monday. I will have a great lineup for June. I'm very excited to do this. Sam, where can people find you? What's your Instagram handler, and where's your office located, or what's your website? I'll put all the other details in our feed.
Sure. So my Instagram handle is at Geller Law, Geller Law PC. And then my website is gellerlawsf.com for San Francisco.
Perfect. And with all that said, I'm Christina Malian from Malian Law. My handles are Malian Law for Instagram, YouTube, and Facebook. So wishing everybody a safe Memorial Day, a wonderful week as we head to June and head to some openings. Be safe, drive safely. And if we can help you, please reach out to our offices. We're always available for a phone call. Have a great night.
Thank you, guys.